Professor Cass Sunstein, calling from the hallowed halls in Cambridge, Massachusetts. Thank you so much for joining us, Professor.
Thanks to you.
So talk to us about what you know about the process now. We just learned 20 minutes ago that Mitch McConnell said they're not going to debate. He's not willing to negotiate the Senate trial rules. One of the big questions we've got, and your colleague, Lawrence Tribe, my former law professor, made the case in the Washington Post, I'm pretty sure it was. Before him, I saw John Dean making the quick argument, and maybe in more full-throated fashion, a fuller argument, that Nancy Pelosi, the House of Representatives, should hold on to the articles of impeachment until blank. First of all, just clarify, is that allowed? Is there anything that requires Nancy Pelosi to hand them over to Mitch McConnell? Talk to us a little bit about the rules going forward.
There's nothing explicit in the Constitution that requires her to do that. We have a bit of a gap in the Constitution that is an unprovided for case. Clearly, what makes her inclined to hold off is a sense that the majority leader doesn't want to take this seriously. And there's an argument, certainly, that she's within her rights in ensuring the House of Representatives impeachment isn't treated as a nullity by the Senate. So I think the best way to understand it is wouldn't be right to say she's violating the Constitution. It would be right to say that she's doing something unusual. But this is a very unusual circumstance where the Senate leader hasn't given any sense that the constitutional duty on the Senate, which is to have a trial, is one that he's willing to respect.
Yeah, the last time this happened, you had 100-0 vote in the Senate about the Senate rules. There was bipartisan agreement about how that should go forward. That doesn't seem to be the case now, or it seems very clear that's not the case now. What about the next step that John Dean even said, hey, this could be held over, these articles could be held by the House until after the 2020 election? Is there anything, again, in the Constitution or anything in, shall we say, the penumbras that suggest that overstates the case, that would be prohibited?
It wouldn't be comfortable, and I apologize for phrasing it in that way.
I've been uncomfortable for the whole time.
Well, clearly what the Constitution contemplates is that the House decides whether to impeach, and if the House then impeaches, there's a Senate adjudication. That's what's contemplated. But in a case in which the Senate, let's say, says we're not going to hold a trial, or we're not going to hold a real trial, the House has its own prerogatives such that to wait until the Senate has agreed to do something that is constitutionally adequate is clarified, and we don't have constitutional adequacy. So I should say I've met Senator McConnell, I've worked with him a little bit, and I like him. So I say this with regret that what he's doing here has a constitutionally illicit character that is treating this as a nothing burger. He can't really do that. It's worse than what he did with Supreme Court nominee Merrick Garland, and that wasn't good. Now, you shouldn't judge a person by an act or two acts, and he has many things he's done that are very good, but this is troublesome.
Thank you so much for sticking with us through the break, Professor. We know your time is precious. Question I wanted to ask, you said that right now the Senate has not laid out a process, a trial, for the analysis, for the evaluation of the impeachment articles that is constitutionally adequate. What are the elements that are constitutionally inadequate, and what would you view as adequate?
What's inadequate is the majority leader saying, I won't do anything that isn't coordinated with White House counsel, and that he and the White House are in lockstep. That's the kind of red color warning. And it's not about the process being specified in those statements. It's a failure to indicate you'll be like what the Constitution requires, which is an independent arbiter. If what McConnell said, and it was credible, was we're going to call witnesses, we don't know how many, but we're going to have some who know something, that that would clearly be adequate if he met Senator Schumer halfway or even a third of the way in Schumer's perfectly reasonable request for witnesses and documents. That would be adequate. If he said, look, I'm not prepared now to say we're going to have witnesses, but I will promise you that if there are gaps after the opening presentations, factual gaps for which documents and witnesses would be relevant to fill those gaps, I promise you, I commit to you that I will take seriously the interest in filling those gaps. I can't commit to anything particular, but I can commit to an honest process. That would be adequate. So for Clinton, there wasn't a specification of we're going to have witnesses and such. It was clear that the majority thought there was a need for them after the opening statements, and that was constitutionally fine. So I think what's needed is something that suggests this isn't a rigged process. It can be one where people have clear inclinations. That's completely fine. But for the majority leader to suggest basically it's over before it started, that's constitutionally inadequate.
After the jury foreman, after Mitch McConnell himself has made clear that he is not an impartial juror, after Lindsey Graham and others have done likewise, is there anything that can cure that?
Well, we the people are in charge of our constitutional order. So if there's sufficient pushback from enough of a cross-section of the country saying a lot of us like President Trump, a lot of us don't, a lot of us think he should be removed, a lot of us don't, but we agree that the Constitution is governing, and you can't conduct a process that isn't a process. So that's the response. I would hope that Senator McConnell would backtrack, not in the sense that he would say, yes, I want the president to be removed. He can make clear that that's not his inclination, but that now that the thing is getting serious, he's going to do what the Constitution requires. And even if inside his mind he's not thinking, I'm going to be impartial here, if he commits that in his role as Senate Majority Leader, he's going to do what the Constitution requires, then we can all take a deep breath.
And what do you think? Say more again. If you were going to say what the Constitution requires for a decent process or even for a good process, you already said some number of witnesses being allowed to be called. What's your short list of elements? And I know that may ask you to repeat a couple things. What's your short list, or it could be a longer list, of elements that you would deem sufficient?
Well, I think there are two sizes that fit both, let's say. One would be adequate, would be to say, as with Clinton, we're going to have a opening set of presentations, and then we're going to have a decision to be made about whether to have witnesses. I think the Democrats reasonably are suspicious of that because they think the fix is in, meaning they're not going to have witnesses or documents. But if the majority leader says it in a way that is sincere and credible, that we're going to have a good faith inquiry into whether we need them, and I commit that to you, then that would be constitutionally adequate. Also constitutionally adequate would be to say we're going to have at least one person, maybe it's John Bolton, who knows something that probably no one else knows or hardly anyone else knows. It may be exculpatory, by the way, of the president. We're going to have him testify. He's not with the federal government anymore. I think that would be, by the way, the constitutionally preferred thing to say now. We're going to have Bolton testify, and we might have others, but at a minimum, we're going to have him, because the White House doesn't have the strongest claim for not allowing that testimony. The strongest claim is when there's someone who is actually still working as the president's advisor.
Well, Professor Sunstein, I really appreciate your time, and I guess I would just chew on this. That imagine a situation. I know it's different, but imagine a situation where the person who was both the judge and the jury foreman started out by saying, "Well, I'm with the defendant." And you can pretend you're not with the defendant, but whatever happens, I'm going to be working with the defendant. We're going to make sure the defendant gets off. And then afterwards, they come back and say, "Oh, but don't worry. We're going to listen to the lawyers, and we're going to let them have some witnesses, and we're going to get in the courtroom. We're going to have people sit in the jury box. We'll even order lunch, and then after that, we'll vote. You can trust us." Would we
Right.
trust that process? I say we wouldn't. And if we wouldn't, would it be more unusual to have that judge and jury rule on the case, or would it be more unusual to wait until there was the potential for a new judge and jury?
I think the analogy is very good. I think you're exactly right. I think the idea of a new judge and jury, that's pretty extreme. And the Senate does have the constitutional prerogative here to conduct.
I just mean
trial.
the next Senate. I just mean after 2020.
Yeah, that would be pretty extreme to hold off on conviction or not after impeachment. But what McConnell himself has done is extreme, and two wrongs don't usually make a right. But it might be that some extreme reaction to what is at the moment constitutionally illicit, as you described with your analogy, it is. And I say that with respect for the Senate Majority Leader and with regret. And I hope he himself regrets some of the statements. It would be better if he would say, look, I spoke in this way. Of course, I'm loyal to the president, but I understand I have a constitutionally prescribed role here, and I'm going to take it seriously. That would be better.